Hi, thanks for joining us for our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is credit and collections best practices. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. Hello, everybody. My name is Alex Barthet. I am a board-certified construction attorney here in the great state of Florida. And today we're going to talk about the best practices to use to improve your credit and collection efforts. So let's go ahead and get started. If you have any questions, you can use the GoToWebinar chat box, which should be on your screen. Go ahead and submit your questions. We will answer them all at the end. Please make sure not to include the names of any people or companies in your questions. So what are we going to talk about today? We're going to talk about various reasons you may want to extend credit, ways to check people's credit, how much credit to extend, how to prevent problems when you extend credit, and then we'll go over some collection tips. And as I said, if you have any questions, go ahead and submit them to us. We'll also have our email address information on the last slide. All right, so what are some of the reasons you may want to extend credit to your customers? Customer loyalty. People like it when they can use your money instead of theirs, so that they can buy things, get paid for those things, and then pay you later. You may decide to extend credit because you feel comfortable with the financial position of your customer. You feel comfortable that if you offer them credit, they will return the money back to you. It may be an industry standard in your industry. So for example, material suppliers, it is pretty common to extend credit to your contractor customers. You can gain a competitive edge by offering credit or offering more credit. So you may be a supply house looking to get certain business from one customer. If you offered better credit terms and more credit, they may buy from you instead of buying from a competitor. Obviously, if you give more credit, that allows people to buy more, which could increase your sales, subject, of course, to you actually collecting the money. So let's talk about some ways to check credit. What do you need to do to check someone's credit? So the first thing you should do is you should have a written credit application. You should collect various information. One, the exact business name of the entity that you are selling to and that you're checking their credit. This is not Smith Construction, it's Smith Construction and Development LLC or Inc. or Corp. So you want to make sure you get the exact name of the business. You need their address. You need their tax ID number. So every business will have a federal tax ID number. They should give you that. That's a great way to cross-reference that the business name you have and the business entity that's filled out on the application is in fact the same entity. If they have a license, it's nice to check to see if they have a license number and that their license is in good standing. That, by the way, is a tip to determine whether or not you should be extending credit. So for example, maybe you are a plumbing supply house, you're selling materials to plumbers, and you do a search and realize that this plumber has his license suspended. That should be a pretty big red flag for you that you probably don't want to extend credit. So collecting license numbers and verifying license information is very important. Bank and business credit references. I would suggest that you get 3 or 4 so that you can check those credit references. You will find that some folks will not respond to credit reference checks. That's why you need more than 1 or 2, because only some people will respond to your credit reference check. And as I said, you need to actually verify the information. Getting the information on a credit application and doing nothing with it does not serve you any good. The other thing that is very important in the credit application is that you are getting their express written authorization to pull their background information and credit information. So you need a sentence or 2 in the credit application telling them that this is what you're going to do and this is what you're using the information for. Other places to check for credit, you can go to Dun & Bradstreet. That will give you some basic information. We typically find that there is less information on new companies and more information on older existing companies. So just keep that in mind. If someone created a business in January and now it's March, there's going to be very little information, if any, in Dun & Bradstreet. Another service is TLO, which is now part of TransUnion. You can sign up and use their service to check for credit. Cortera, which is now part of Moody's, also another place to check for business credit information. Other free places you can go to, because Dun & Bradstreet, TLO, and Cortera all typically require a fee for their service, you can get information from the Secretary of State, that's sunbiz.org, to verify that a business is in business. As well, you want to verify that the information that they tell you is accurate. So if they say that the business has been around for 10 years and you go to Sunbiz and you realize it was only formed 2 years ago, that should raise some red flags. So sunbiz.org is a great way to determine some basic corporate or LLC formation information. So again, I mentioned this before, a very important tip: make sure that the contract and the credit application have the exact name as it appears on sunbiz.org. You would be shocked to find that the Secretary of State will allow very similar companies to exist, very similar company names to exist in the Secretary of State database. So I could be Smith Construction and you could be Smith Construction Group. And if I don't verify, if my supplier doesn't verify that information, they may pull the credit on the wrong business. So again, make sure you know exactly which business is applying for credit and has a contract with you. So let's talk about some ways to check credit in the public records. So here are some easy tips that I strongly encourage you to use in addition. So even if you're using Dun & Bradstreet or TLO, I would suggest that this becomes part of your routine search, because those databases or those services aren't perfect and you may find information in other places. So you can Google the county recorded documents section. So you type in Miami-Dade County, Lee County, Pinellas County recorded documents, and you can look for liens, releases, judgments, property transfers. So this is any document that's going to be recorded in the public record in the county that you're searching for. Again, very good way to determine what exists for this company. And by the way, for any of the individuals that you're extending a personal guarantee to, when we'll talk about personal guarantees in a few minutes. You can Google the name of the county plus county property appraiser, and you can look for any current property ownership. So one of the questions in your credit app may be, do you own any property? Maybe they list a piece of property. You can search in that county to see if they are actually the owner. If they don't list anything or you don't ask the question, you can still find out by doing a search for the people or the company. And then if you want to look for any open or closed civil or criminal cases, do a search for the name of the county, court records, and that will take you to the clerk of court in the county where the case may be located. So again, if I'm in Pinellas County, I type in Pinellas County court records, and I can type in the name of the business in that search box there on the Pinellas County court records website, and it will tell me if there are any open or closed civil or criminal cases. And nowadays you can get almost everything available online to see the actual court record. So you can look at court filings in many types of court cases right from your computer. I would also suggest just use good old Google. Type the company and or the principal's names into Google. Ideally, it's a less common name, so you should hopefully find your company versus some other company, but on the first 2, 3, 4 pages of Google, you will usually find a fair amount of useful information. Online reviews, Better Business Bureau reviews, license complaints, mugshots, bankruptcies, related companies, their website or websites that may reference them. All great information to get a more complete picture of the business you intend to extend credit to. So how much credit should you extend? This is not an exact science, unfortunately. The real question is, how much are you willing to put at risk when you extend credit? And I think the answer to that is the debt secured? Do you have a personal or corporate guarantee? Do you have a joint check agreement? Do you have lien or bond rights? So let's run through those so that you have a better understanding of how to secure each of those rights to make sure that you can extend reasonably enough credit to help your business but not put you at risk. And I would strongly suggest that you start slow and extend credit over time when you have a history of payments, just like a bank would do with when they extend credit on a credit card. So let's talk about one of the best ways to protect yourself when you extend credit, and that is a personal guarantee. What is it? It is a written promise from one person or a group of people to pay the debts of the business. We don't normally see it this way. It can include, and if you want the best protection, it should include husbands and wives, spouses. And the reason is that, especially in Florida, which is a very debtor-friendly state, if you have a personal guarantee with me, but all of my assets, my bank account, my investment properties are with my spouse, held as jointly as tenants by the entirety, which is a legal term that says each of us own that asset indivisibly 100%. You can't touch it. So let's take an example. You are a supply house. You extend credit to me. I sign corporately and individually, but you don't have my spouse sign. I don't pay the bill. I owe you $50,000. You sue me. You get a judgment against my business and against me. You try to execute that on that judgment against me. And what will happen is that if my bank account, for example, is held jointly between me and my spouse, you will not be able to get any of it. Don't think you can get half of it, because if it's tenants by the entirety, if that's how it's titled, the bank account, none of it is available to you. Now, if you had my spouse sign the personal guarantee, then all of it would potentially be available, subject to some limited exceptions. So if having a personal guarantee is better than not having a personal guarantee. But what is just as important is understanding the limitations of what you get with a personal guarantee of one member of a married couple. Know that the personal guarantee does not need to be conditioned on the business not paying, meaning when we pursue judgments or claims for our clients that get personal guarantees, we don't need to sue the business to go after the guarantors. We can go after the guarantors and not go after the business. So again, it is joint and several liability if that is the way the personal guarantee is written, which it should be. It can include all debts even without their consent, and it covers them even after they leave or sell the business, unless, of course, they revoke their guarantee. So for example, let's say a partner and I are in the business. I leave the business, but I sign the personal guarantee. My now former partner runs up $100,000 debt and they pursue the debt. They would sue me as a guarantor because even though I left the business, I am still on the guarantee and I never revoked it. So typically to revoke it, I would have had to have said to them, hey, I am no longer in the business. I do not consent to being subject to this guarantee. It doesn't alleviate the debt that has been incurred prior to my revocation, but subsequent to my revocation, it will be hard for them to pin on me the debts that were accrued after I left and gave them my written revocation. Again, having a personal guarantee is great. It needs to be in writing. It should be prepared by a lawyer or reviewed by a lawyer because it needs to say some very specific things to make it enforceable to get the best bang for your buck. We see this less often, but occasionally, and that is a corporate guarantee. It is just like a personal guarantee, but instead of a person guaranteeing it, it's one business guaranteeing the debt of another. So when you extend credit and you get a personal guarantee, in addition to running the credit of the company, you should run the credit of the guarantor. Remember, you need their express written consent to run their credit and get a background search. The same thing is true for a corporate guarantee. If you're extending credit to one business and get a corporate guarantee, then you need to get that corporate guarantor's consent to run their credit and get background information. So why would you need a corporate guarantee? Well, maybe I am a developer and I've created this single purpose entity to build this building, and I need to buy a generator from you, and you agree, and I want to buy it on credit, but you know that this is a business I just formed. So I may say, look, you have this parent company that owns this entity and all of the other developments that you are part of. I want that parent company to guarantee the debt of this subsidiary company. So that's an example of when you may want a corporate guarantee. A joint check agreement. So joint check agreements are a written promise, usually from the contractor, sometimes from an owner, to pay a subcontractor or supplier directly or jointly when a debt is accrued. Joint check agreements are ways to limit your risk. They are governed by their terms, so read them carefully. I would suggest to you, if someone is handing you their pre-prepared joint check agreement, it probably doesn't provide as much protection as you're hoping for. So typically we see contractors who have standard joint check agreements. You will see that they are not so great. They're not bad, but they're not that great for you as the supplier or the person relying on the joint check agreement. So another pro tip, what if the joint payee refuses to sign the check, right? So we enter into a joint check agreement. The joint check agreement typically says that the contractor is going to issue a joint payment. So that means a check payable to ABC subcontractor and XYZ supplier. And in the course of that transaction, the subcontractor disappears, refuses to sign the joint check. So what do? Now you have this check that's sitting out there, and unfortunately, you can't get it endorsed to you, because to have a joint check endorsed to you, that means that you need to have that other party sign it. If they're not available to sign it or refuse to sign it, now you have a check that is available, but you can't do anything with it. So you want to make sure that the joint check agreement says that after a certain period of time, 3 days, 5 days, 7 days, if that joint check is not properly endorsed by the joint payee, the contractor will issue it as a single party check payable to you. So let's talk about probably the most important way to get your debt secured, and that is with a lien or a bond claim. So what is a lien or a bond claim? It encumbers the property with a lien, or the contractor, if he issued a bond, it encumbers that bond with your claim, your debt that you have now extended credit for on this project. As most of you probably know, the general timeline is within 45 days of your first work, you need to serve a notice to owner. Within 90 days of your last work, you need to record a claim of lien or serve your notice of non-payment. And within 1 year, you have to file a lawsuit to foreclose on the lien or on your notice of non-payment. Again, of all of the ways we talked about securing your debt, personal guarantees, corporate guarantees, joint check agreements, the most effective way to get paid for any credit you extend is ensuring that you properly protect your lien and bond rights. So if there's one thing you need to do after leaving this presentation is make sure that you have a process in place that every time you extend credit, you are properly protecting your lien rights. One pro tip as well, know that sometimes you may be on projects, typically larger projects that have subguard, and you may perceive if you're a subcontractor, subcontractor, or supplier, well, I was told there's subguard, so I must be protected by that. That is not true. So if the contractor issued a payment bond, it would protect you with your rights to collect on the debt would be protected by the by the payment bond. If the job doesn't have a payment bond, then your rights are protected by a lien. But you need to enforce your lien or bond rights if they exist. Do not believe that subguard protects your rights. Subguard protects the owner and the contractor if a subcontractor defaults. It does not protect you as an unpaid supplier, subcontractor, or subcontractor on a project. So what are some ways to prevent problems when you extend credit? Number one, rerun credit at least annually. You should make sure that the information you have is checked because people's credit changes. Sometimes it goes up, sometimes it goes down. You need to check on the equipment delivery, you need to check on the equipment, the delivery status, and the location of your goods. Are they in fact being, so one of the things we see sometimes is when we represent equipment suppliers, the equipment gets delivered to job one, it gets used for 2 weeks, and then the customer picks it up and moves it to job number 2 without telling you. So, now on some pieces of equipment, there's GPS tracking, but that's not guaranteed that that exists. But, also if you're a supplier and you provide roof tiles, did they get delivered to job A and then they pick them up and move them to job B? The reason that this is important is because it will affect your lien and bond rights, which, as I said before, are the best way to protect your extension of credit. You need to meet with your customers and listen carefully. Sometimes they will tell you things about their business or about projects that should be clues about whether or not you should be extending more credit or what you should do with the credit you've extended. Maybe they're telling you they have difficult owners or contractors that they're dealing with. Those are the things that you need to pick up on. Communicate with your sales team. So if you're in credit and you deal with sales, sales may have information about what's happening on projects and with your customers you should be aware of. You need to keep good records. When clients come to us and they want us to collect on a debt that they have, the number one thing that we need are records. Sometimes clients think they have a credit app and they don't. Maybe there was an old credit app and it's not the new version of the credit app. Maybe it was the friend of the business owner and therefore no credit app was signed. So make sure that you double check your records. Some other records that are great to have are delivery tickets with ideally legible information about signed delivery tickets. So keep that in mind. One pro tip, do not list the credit limit on any credit applications that you prepare. Sometimes we see there's a little box that says, credit limit. I would remove that from your credit application. I would have that information kept internally. And the reason is there is some case law in Florida that if you indicate a credit limit and you extend beyond the credit limit, that may, any debt over that amount may be on you because you extended credit beyond what you should have extended. So don't even put it on the credit application, because more likely than not, what we see is someone comes in, they get credit to $50,000, and slowly over time you increase it, they don't pay you, and now that $50,000 that's written on that application is getting used against you later. So let's talk quickly about some collection tips. You need to contact delinquent accounts often. Do it verbally, do it in writing. Be nice but firm, but trust me when I tell you that the squeaky wheel gets the grease. Those folks that use us, the clients of ours that have the best collection success rate are the most proactive in their efforts to collect before they ever send us a file. Negotiate with the actual decision maker. If you're negotiating with an intermediary that says, well, I need to check with my boss, you know, you're going to find that the negotiation is much less effective when you're trying to resolve a debt. Bypass that middle person to the extent you can, talk to the decision maker. It will be faster and more fruitful. Some other collection tips. You want to condition a credit on prompt payment. Do not give unconditional credits based on verbal promises. So what does that mean? That means if you are owed $100,000 and I tell you, okay, look, I'll pay you 80,000 and we're good. And then I convince you to send me a email or a credit memo that says, you know, credit of $20,000, and it doesn't have a condition on it. And then I never pay you the $80,000. When you sue me, I'm going to use that unconditioned credit against you. I'm going to say, well, I don't owe you 100, I owe you 80, because look, you gave me this credit memo. So if you're going to issue a credit memo, you want it to say this credit is expressly conditioned upon the undersigned receipt of, in an example, you know, the receipt of payment of $10,000 by May 25th to 2024 in cleared funds. Otherwise, this credit memo is void. Again, very clear that it's conditioned on you actually receiving a certain amount of money. If you want to send it via email, the email could say, as discussed this morning, we will accept a payment of $10,000 against the $12,500 owed on invoice 1234, only if payment is received by the undersigned by May 25th, 2024 in cleared funds. The payment never arrives, no problem. It's very clear that your agreement to accept a reduced amount was conditioned on payment by a date certain. That didn't happen, the reduction goes away. Don't delay in initiating the legal process. If you are not making headway, don't wait to enforce your legal rights. Hire a lawyer and start collecting on that debt ASAP. The worst cases we get are cases when someone comes to us with a very old debt versus those claims that when a client comes to us and it's, you know, 30, 60, 90 days old, again, that's a much better case for you. It's easier to collect than waiting 6 months, 10 months, a year. So with that, Jesse, do we have any questions?
Hi, yes, Alex, that was incredible. Thanks so much for all those tips and advice that you were able to provide us. Yes, we do have a couple of questions that came through. This one, it looks like, is probably pertaining to one of the comments that you made. It says, if they move my materials to a new job site without informing me, what is the recourse if a NTO wasn't filed on the new site location?
So you always have rights against your customer for the things that they purchase. So if I buy things or rent things and I take them all over the place and I don't tell you, I still owe you the money. What you lose, unfortunately, is your lien rights, because the lien law does not care that I move them around, because that cannot prejudice the owner who was not privy to any of these transactions. So if you deliver product to job site 1, and I take half of them and I move them to job site 2 without telling you, your lien rights, assuming you sent the notice to owner on job site 1, would be for the half that stayed there, not for the half that left. And on job site 2, you would have no lien rights because you never sent a notice to owner. And again, the fact that the customer never told you is not a defense, or it doesn't give you lien rights. What's next, Jesse?
Understood. And then this one, it says, can I include my attorney's fees or filing fees in the cost of my lien, or in the total amount of for my lien?
So there are 2 ways in Florida to recover your legal fees. So one is if you have lien or bond rights and you pursue those lien or bond rights. So you wouldn't include them in the lien specifically. You have that legal right based on the lien statute. So when you record the lien, it doesn't have to say anything. You hire a lawyer to file a lawsuit to foreclose, and if you win, then that lawyer should be able to recover your legal fees, subject to the judge agreeing, of course, but because you sued on the lien. If you have a credit app or a contract, then you need to have a written provision in the credit application or contract that says the winner gets their legal fees. That's the second way in Florida to recover your legal fees, is to have a written agreement signed by the parties that says the winner gets their legal fees. So if you come to my house and we have a handshake deal and I don't pay you, you will not recover your legal fees on our handshake agreement because we don't have a written agreement signed by the parties that says the winner gets their legal fees. Which is, by
Wonderful.
the way,
Okay, thank you.
the reason why you want to make sure you have such a provision in your written agreements.
Perfect. Okay, so then we have another question that just came through. It is, what is the best way to go after a service customer, like smaller accounts, such as a hospital or nursing home that owes upwards of $10,000? Do we have any legal rights?
You absolutely have legal rights. The law in Florida recently changed, and it increased the amount that you can recover on your own in small claims court. It used to be $5,000, now it is $8,000. It will likely go up slightly more in the next year or two. So number one, I would say for any debts that are small, several $1,000s, you should consider bringing the action yourself in small claims court. So you don't have to pay a lawyer to handle the case. If you're owed $10,000 and you don't want to pay legal fees, then you can sue them in small claims court, but just know that if you prevail, you'll only get $8,000, meaning you'll walk away from the $2,000, the amount over the jurisdictional limit of the court. If you want to take a case to small claims court, I would suggest you Google the county you're in with small claims court, and it will take you to a page with managed by the clerk of court in that county, and they usually have all the forms you need. Some have how-to videos, some have step-by-step guides right online. It is not complicated. It's a little intimidating, but it's not complicated to do yourself. But if someone owes you money, you can absolutely sue them, either yourself or through a lawyer. And depending on the type of service you do, you may still even have lien rights, and therefore you should use SunRay and record your lien, because lien rights are, again, the best way to get paid.
Perfect. Well, hopefully that answered some of those questions for you guys. If you do have another question that wasn't addressed, you can feel free, please reach out to me. I would be happy to help answer any questions as soon as I can. Alex, can you go to the next slide for us, please? All right, so who is ready to win a gift? We're having a little pop quiz to take a look at these questions. If you feel like you know the answers, go ahead and chime in our questions section, and we will be sure to send you guys over a SunRay gift. So the first one is, what is the NTO deadline in Florida? I know Alex has talked about it. I know we preach about this constantly, so please take a look. What do you think it is? Answer it in. And then for the second question, what is the lien deadline in Florida? So again, take a look. If you know those answers, go ahead and chime in, send it over to us. And again, we'll be happy to send you over a little gift. I do see a couple of correct answers, so that's wonderful. All right, so here we have our SunRay resources to help you guys stay organized, know your deadlines, secure your lien rights. So go ahead, scan that QR code to access these incredible resources. We've got deadline calculators, project information sheets, the lien laws by state. So check it out, see what you can find on there and be able to utilize to stay organized. Next slide, please. Wonderful. All right, so we have a new collection services at SunRay. So if you need help with your collections, go ahead and reach out to us. You can send us an email, give us a call, and we'll give you guys some more information on that. All right, so our next webinars with Alex, we have lock-in payment plans like a pro, 4 expert tips to get paid and avoid litigation. That's going to be Thursday, April 4th, so just about 2 weeks away. So go ahead and check that out. And then the next one is how to get the bonding company to pay. That's going to be on June 13th. So go ahead and register for free at sunraynotice.com/education. All right, so if you are in the Fort Myers area, Alex is going to be presenting alongside of Ariella from SunRay for our live seminar on April 11th. That is going to be how to get paid faster with liens, bonds, and contracts. If you are interested, register at sunray.com/seminar. We also have 2 additional seminars that will be in the state of Florida. We have one in Miami in May and another one in Tampa in October. So if you guys want to come and join us for a live seminar, please check it out. Go ahead and get registered for the one that's close to you. We'd love to be able to see you guys. Next slide, please. All right, so this slide, if you don't mind, take a moment, scan this QR code, give us a review on Google. We appreciate any of the feedback we can have. It helps us improve ourselves and make sure that we're reaching other contractors like yourselves and getting the word out there to them. All right, and with that, that is all we have for you guys today. Thanks so much for everybody that was able to attend. We hope to see you guys at our next webinar, and I hope you have a wonderful and sunny day. Thanks again, Alex, for everything.
Thank you.